Hello, I'm A.G. Harmon, and thank you for attending our second presentation in this year's Student Scholar Series. As you may know, the series was instituted 3 years ago in order to recognize notable legal scholarship produced by members of the student body during the previous academic year, and to foster the skills associated with presenting and defending the scholarship in a professional, conference-style setting. Today's presentation will be made by third-year student Melissa Nonaka. But before I introduce Melissa, I'd like to first introduce the respondent to the presentation, Professor Megan LaBelle. Professor LaBelle earned her B.A. summa cum laude from the University of California, Los Angeles, and her J.D. from the University of California, Davis School of Law. After several judicial clerkships, Professor LaBelle spent several years as a commercial litigator with the Los Angeles law firm of Munger, Tolles, and Olson. And prior to joining the CUA faculty, Professor LaBelle's practice focused on intellectual property and other complex civil litigation matters. I'd like to thank her for being with us today. Now let me introduce our presenter, Melissa Nonaka. Melissa graduated from Boston College in 2006 with a Bachelor of Arts degree in psychology and a minor in Hispanic Studies. After college, she returned to San Diego, her home, to work as a paralegal at an immigration law firm for 2 years before entering CUA. After graduation, she plans to stay in the D.C. area to pursue a career in immigration law. In 2009, Melissa, a certificate candidate for the Comparative and International Law Institute here, studied abroad through the International Business and Trade Summer Law Program. In Krakow, she took a class on international intellectual property, co-taught by Professors LaBelle and Susanna Fisher of CUA. And there she learned about IP law in general, and specifically the protection of IP rights in the international arena, the agreement on trade-related aspects of intellectual property rights, the TRIPS agreement. In choosing a topic to write on as a staff member for CUA's Journal of Contemporary Health Law and Policy, who brought her article to the committee's attention, she took the opportunity to explore her interest in the health-related aspects of the TRIPS agreement. Specifically, her research focuses on recent TRIPS-compliant actions by the members of the European Union that have significantly disrupted the flow of lawful generic medicines to the world's poorest populations. I now turn the floor over to the second of our 2010-2011 student scholars, Melissa Nonaka. The topic of her presentation, Enough is Enough, India's Fight Against Seizures of Lawful Generic Medicines. Melissa.
Thank you, Professor Harmon, for the introduction, and thank you, Professor LaBelle, for being my respondent today. I also would like to extend a thank you to the Journal of Contemporary Health Law and Policy for nominating my work. Without that, I wouldn't have this opportunity today. In recent years, shipments of legitimate generic drugs manufactured in India and bound for developing and least developed countries have been seized in transit at European ports in a manner that is inconsistent with the TRIPS agreement, which governs the protection of patent rights and other IP protections in the international realm. In 2008, 17 total drug shipments were seized by Dutch officials while in transit to 7 different developing and least developed countries in Africa and South America. All but 1 were of Indian origin. 16 out of the 17 shipments were eventually released as legitimate generic drugs. 1 shipment bound from India to Peru was detained for as long as 8 months, and another for 5 months. Another of these shipments involved blood pressure drugs en route from India to Brazil. In response to a threat to destroy the drugs after being held for 36 days, India was forced to take the shipment back. The shipment was enough to treat 300,000 Brazilians for a full month, but it never reached Brazil. Such seizures continued into 2009 and by other European Union customs officials. In May of 2009, German officials seized a shipment of generic amoxicillin en route from India to the Republic of Vanuatu in the Pacific. The shipment was released 4 weeks later when they found the drugs to be legitimate generics. In October of 2009, French officials seized a shipment of antiplatelet drugs en route from India to Venezuela. These drugs, again, were determined to be legitimate generics and released after 8 days. India has developed its reputation as being the pharmacy of the developing world, as Indian generics manufacturers have consistently provided affordable medicines in generic form to countries and organizations all around the world. Generics drugs are produced and distributed without a pharmaceutical patent. The first inventor of a new drug is afforded a pharmaceutical patent which is national in scope. The patent allows only the first inventor to sell the drug, or the branded drug, for at least 20 years, providing that inventor with the opportunity to recover research and development costs. Generic drugs contain the same active ingredients as the original patented drug, and therefore are not harmful for consumers. They are legitimate drugs. They are identical to the patented drug in dosage, safety, intended use, and effectiveness. In most cases, generics are available once the patent has expired, and in other cases, generics are produced in violation of an existing patent. The benefits of a generic drug are that it is a low cost. In some cases, there is a significant gap between a patented drug that is branded and generic. For example, the brand name drug Solodin, whose generic is called minocycline, is used to treat bacterial infections including pneumonia and other respiratory tract infections, acne, and infections of the skin, sells at an average cost of $608.17 for a month's supply, which is $544.89 more than the average cost of the generic version, which sells for $63.81 for a month's supply. As a result, generics are also often the only medicines that the poor can afford. Generics also serve as the backbone of public health organizations and civil society organizations in developing countries. Examples of such organizations are the Bill and Melinda Gates Foundation, the William J. Clinton Foundation, and Médecins Sans Frontières, or Doctors Without Borders. On the flip side, counterfeit drugs are produced and sold with the purpose of deceiving its origin, authenticity, and effectiveness. They may include products with no active ingredient, insufficient or excessive active ingredients, or wrong active ingredient overall. As a result, they may be improperly processed by the human body, and they are harmful to consumers. Counterfeit drugs can be produced for both brand name drugs as well as generic drugs, and they are illegitimate drugs that should be kept off the market all around the world. To bring all this into the context of the international realm, I want to talk about the World Trade Organization and the TRIPS Agreement, which governs protection of patent rights on the international scale. The World Trade Organization is a member-driven international organization that monitors the trade in goods, services, and intellectual property. The WTO is not primarily responsible for aiding in the public health needs, but once it began to regulate patent policies on an international scale, specifically through the administration of the TRIPS Agreement, it became a central focus in the global public health crisis. As pharmaceutical products found markets across borders, the national scope of patents began to raise concerns regarding the extent of enforcing patent rights in other nations. On January 1st of 1995, the TRIPS Agreement, or the Agreement on Trade-Related Aspects of Intellectual Property Rights, came into force as the minimum standard to harmonize the protection of IP rights on an international scale. It covered all forms of intellectual property, and pharmaceutical patents constitute only a portion of the agreement. In regards to patents, they had to be granted in all fields of technology, including pharmaceutical patents. And this is a big change because many developing and least developing countries did not have patents for pharmaceutical products. And the TRIPS Agreement was the first time that it required it at a minimum. These patents had to be enforceable for at least 20 years. And furthermore, states are not allowed to afford any benefits to local citizens which are not available to other WTO member states. There were transitional periods for compliance provided according to the developmental state of each country. Developed countries were provided 1 year to comply. Developing countries were provided 5 years to comply. And least developed countries initially had 11 years, but that was extended until July 1st of 2013, with a separate deadline of January 1st, 2016 for pharmaceutical patents. As a minimum standard, the TRIPS agreement allows its members to implement more extensive protection of IP rights, but as the preamble states, the enforcement of IP rights should not themselves become a barrier to legitimate trade. Over time, the applicability of the extensive protection of IP rights became a concern when it conflicted with public health interests. In March of 2001, the South African government was attacked by litigation attempts by 39 pharmaceutical companies from all around the world, claiming that the country's import of cheap generic versions was a violation of their patent rights. South Africa had implemented legislation to assist in the access to essential and affordable medicines to millions in South Africa. The pharmaceutical companies eventually withdrew their claim after significant pressure from the international community. But questions remain about how such situation should be handled under the TRIPS agreement. In order to clarify the concerns that were raised regarding public health interests, a compromise was settled among WTO members in the Doha Declaration in 2001 of November. It was agreed that the TRIPS agreement should not be interpreted nor implemented in a way that would prevent the protection of public health. It recognized that the public health concerns affect many developing and least developed countries in this world, and it precluded the implementation of more extensive IP protection if they counter those public health interests. Keeping in mind the underlying objectives of the TRIPS agreement and the Doha Declaration, I'd like to now go back to the issue of seizures again. So this is about Indian generic drug shipments bound for developing and least developed countries en route through a European port, and they're being seized at these European ports. The EU member states have been taking such actions based on EC Regulation 1383, which authorizes customs officials to take action against goods suspected of infringing patent rights or other IP rights. It allows a rights holder to submit an application for detention by EU customs officials of any suspected goods at the external border. And I wanted to talk about the procedural aspects of how this is done in the regulation. And the regulation, with its strict protection of IP rights, is in technical compliance with the TRIPS agreement because it allows each member state to implement far more extensive procedures. But once a member state submits an application to the EU customs officials, they may seize suspected goods and notify the rights holder and interested parties of the detention. The right holder then has 10 working days from receipt of the notification to initiate legal proceedings or go through a simplified procedure, which I'll talk about in the next slide. And if proceedings have not been initiated, the drugs will be released. And the initial period of 10 working days may be extended by an additional 10 working days, so the maximum amount of time allowed would be 20. And then once an application is submitted, there's an option provided in Article 11 of the EC regulation that allows for a simplified procedure. This enables customs officials to have goods abandoned for destruction under customs control without a determination of the IP infringement. And this is upon agreement between the rights holder and the interested parties. And this has to be done within the initial 10 working day period, which again can be extended for another 10 days. And this agreement is presumed to have been accepted when none of the interested parties has opposed the destruction. If there is no application submitted by the patent holder, customs officials who have sufficient grounds for suspecting that the goods are infringing on IP rights may suspend the release of goods or detain them ex officio. The rights holder will then be notified of the detention, and then they'll have an opportunity to submit an application within 3 working days. And then the goods will be released if no application is received within this time period. But if an application is received within this time period, then that starts the clock again for the 10 working days to either initiate a legal proceeding or to go through the simplified procedures. So the regulation, like I said before, is in technical compliance with the TRIPS agreement because it allows each member state to implement far more extensive measures. However, the issue becomes whether mere technical compliance with TRIPS actually serves its underlying objectives of promoting public health. This regulation, or at least the manner in which it is carried out with the recent seizures, has proven to interfere with legitimate trade as it creates additional and unlawful barriers to the access to much-needed legitimate generic medicines. India and Brazil and other constituents have brought this issue up numerous times in TRIPS Council meetings, urging the EC to keep in mind the public health interests when carrying out extensive measures against goods that are suspected of infringement. The EC's response, of course, is legitimate. They state that their regulation fights against counterfeit drugs in the interest of, counterfeit drugs, and that the prevention of such drugs from reaching the poor population directly serves the public interest, which is the intent of the TRIPS agreement, because it would stop the traffic of these fake medicines, the consumption of which would be severely dangerous. But the question is raised, however, why so many legitimate generics are being seized and held for long periods of time, even after they are determined not to be counterfeit. And is the EC's reasoning just a cover-up to enforce patent rights at a maximum and inhibit the market of generic drugs, despite the danger to public health? There are several ramifications of such continued drug seizures and delayed or even canceled shipments. First, the developing and least developed countries have little or no access to affordable and essential medicines, causing harm to those in need. As I stated earlier, there are incidents when such drugs, after they're seized, never make it to the destination country, and large populations of those who need them don't ever have access to them. In the case with Brazil, 300,000 patients failed to receive their blood pressure medication. In another incident, HIV/AIDS patients in Nigeria were threatened with delayed shipments because of a seizure that occurred in the Netherlands of a shipment of Indian generics that were actually purchased by UNITAID, the purchase arm of the WHO, the World Health Organization, and were to be distributed by the William J. Clinton Foundation. Not only was the shipment pre-qualified by the WHO, but it was even tentatively approved by the U.S. Food and Drug Administration. So they seem to be pretty legitimate drugs. And ultimately, these drugs were, in fact, released as legitimate drugs. But the UNITAID representative made it clear that any interruption in AIDS therapy is extremely dangerous because they can develop a resistance to the medications. A second ramification is that Indian generic drug shipments must be diverted to alternative routes, causing additional costs and burdens that would make generics less affordable. Now, this is when Europe is used as the in-transit route, and the question is, why is Europe used as a transit hub? Europe's geographical location makes it very convenient, and a lot of suppliers of generic drugs have established relationships with European airports as well as European airlines. And Europe has established trade routes that are most affordable for such suppliers. And shipping through other ports may be an option, but that has been done already. And it's been found that shipping through other ports such as Singapore or Malaysia have doubled the cost and is not very feasible. A third ramification is that Indian generic manufacturers and civil society organizations will suffer from reduced credibility. Continued seizures and delayed or canceled shipments would weaken the reputation of the Indian generics manufacturing industry as reliable and affordable suppliers. They have developed successful relations with numerous developing and least developed countries across the world as their pharmacy for affordable and reliable medications that are safe. reduced credibility would certainly be harmful to these manufacturers. The credibility of civil society organizations that rely on Indian generics would also be damaged. Certainly troubling when organizations such as the William J. Clinton Foundation and the Bill and Melinda Gates Foundations cannot properly provide proper access to affordable medicines to those who need them. In order to find a solution to this problem, we must recognize the competing interests and acknowledge that the EC Regulation 1383 is in technical compliance with the TRIPS agreement. The TRIPS agreement allows for border measures as long as they do not counter public health interests. In compliance, the EC regulations allows for border measures to protect against counterfeit or fake drugs, so this does serve the public interest. A complete prohibition of EC's implementation of border measures may be detrimental to the poorest populations in the world because they do serve to protect such populations from dangerous and harmful medicines. Therefore, in the interest of public health, the shipment of counterfeit drugs, which are again dangerous, should be intercepted. Generic drugs, or those in violation of a patent, are not a danger to public health. These are safe drugs and should not be intercepted. In order to reconcile the competing interests, transshipped drugs should undergo an expedited review process. There should be more communication and transparency among customs officials, and a TRIPS authorized list of drugs should be produced. The customs officials should first determine whether the drugs are counterfeit, and then when they're not found to be counterfeit but merely generic, they should release them to the destination country. If there is a patent violation, then the patent holder can be notified immediately, and they'll still have an option to enforce their rights at a later date. But at least in this way, a shipment of safe drugs are well on their way to their destination country. If these changes are made, India can continue to serve as the pharmacy of the developing world. Civil society organizations can continue to rely on Indian generics, and the world's poor can continue to benefit from the access of affordable and essential medicines.
Thank you. So first I'd like to say that these are really important and interesting issues, so I'm very glad that Melissa has chosen to write and research about such an important topic. My first question is about your proposal. So if I understand your proposal correctly, you suggest that the customs agents should make a quick determination about whether the drugs are counterfeit or not, and even if there's a suspicion that the drugs infringe a patent, the customs agents should nevertheless release the drugs to the destination country as long as they're sure they're not counterfeit. So my question is whether your proposal applies across the board. And what I mean is, should this proposal apply regardless of what the destination country is, or would your proposal only apply if the destination country is a developing or a least developed country?
I would say that it would really only apply to developing or least developed countries. The reason is because this is a public health issue, a public health crisis issue. And these countries, these developing countries and least developed countries do not have the manufacturing capability. They don't have the money, but they also do not even have manufacturing capability. They don't have, the research and development, the science. They cannot produce their own generic medication. And so I would say they are the ones who are in need, and they certainly rely on generics from India. They have been for many, many years. And to stop them from accessing generic drugs that are absolutely safe and able to be consumed by them to prevent them from accessing that is not right. And as far as the U.S. or, if it were to apply across the board, the U.S. does have manufacturing capabilities. And yes, about 80% of generics come from India, but they have the ability to manufacture their own generics and medicines in their own country, in our own country. And so I would say that it should strictly be applying to developing and least developed countries.
Okay, and then my second question to follow up on that, which I think follows directly from your last point, is if you err on the side of releasing the drugs at the expense of the rights of the intellectual property owners, then arguably your proposal will facilitate patent infringement, or at the very least, it doesn't prevent patent infringement at that time. So some might argue that as a possible consequence of your proposal, pharmaceutical companies which we incentivize to invent new branded drugs by granting patent rights, right? That's the purpose of our patent system, is it's a trade-off, and we in exchange for inventors inventing new drugs, inventing non-obvious drugs, and fully disclosing their inventions, in exchange for that, we grant this exclusive right to use, manufacture, sell, or offer to sell that invention for a limited period of time. So in the U.S., that's 20 years. So my question is whether your proposal might discourage or disincentivize pharmaceutical companies from investing the significant resources in research and development that's necessary to develop new drugs. Might they be discouraged or disincentivized from doing that as a result of your proposal?
Well, specifically as a result of my proposal, I don't think that it would facilitate patent infringements. I guess it is really important to protect patent rights, because it does, again, not only does it allow the company that produced the drug to kind of recover the costs of research and development, but as you said, it incentivizes further research, and we all would like to have more new drugs on the market to help those in need. But my proposal specifically allows the patent holder, although not at the moment of the seizure, but if they choose to do so, they can follow through and enforce their rights at a later date. The issue here, again, is the public health issue, and so my proposal just wants to make sure that the populations in need are having access to the public health, to the generic medicines, and I think that it still allows the patent holders to enforce their rights and collect whatever remedy they need at a later date. So to answer your question, I don't think that it would facilitate any more patent infringement.
I think this is something we always have to balance, though, when we're considering intellectual property rights issues. You have to balance here the interests of the rights holders in their patented invention against the interests of the public, or of, in particular, poor patients who need their medicines. And I think I agree with Melissa that you need to err on the side of the interest of the public health. And while it could make it more difficult in some situations for intellectual property owners to enforce their rights, that seems to be a reasonable trade-off.
Open up to questions, but I'm going to ask one myself first. I was a little, the process of this, the EC, and this is what they did, how do they learn, what's the process? Does the rights holder contact them and they say that this is, we suspect that there is that these are counterfeit drugs, they're not generic drugs? Is there any threshold of proof you have to show them? How does that work? I mean, isn't it clear sometimes that if you say these are generic drugs, there's no doubt about this, and they should, it should be expedited? Is there some level of proof you have to say that these really are a danger to me? What's the protocol for all of that?
Well, that's actually something that we were kind of struggling with as well, because the EC regulation is very vague, and that is initially the problem. And even the Dutch foreign minister has said that, Minister of Trade has said that it's too ambiguous. It's not clear as to what's prohibited, what's permitted, and this whole, I guess, issue is raised because India and Brazil and other constituents have been seeking some kind of clarification from the European community, which they've kind of provided, not kind of provided. But as far as the protocol, it says that a patent holder, if they were to find out about a shipment that's coming in that is suspected of infringement, then they would submit that application to the customs officials. And the application itself has to, describe what your drug would look like, and all the kind of the characteristics to make it a little more easier for the customs officials to spot it when it's coming through. But as far as whether there is actually a patent infringement, that doesn't come, that's not something that the customs officials decide. So that is decided after the drugs are seized, and then the customs officials notify the patent holder, we've seized something that we suspect is an infringement, and then the patent holder can then decide whether they want to initiate proceedings to determine whether there's an infringement at all.
Yeah, this is one thing that's so troubling about this regulation, is that there doesn't seem to be a lot of guidance, very much guidance at all, for customs officials who are not experts in intellectual property law. And one important thing to point out is the customs officials are seizing these shipments not just because they think they might be counterfeit, that's a subcategory, but because they think they might be infringing intellectual property rights. And if they think they're infringing, they contact, I'm sure, through this application process, they get in touch with the patent owner and then try to make that determination. But they're not experts in IP law, certainly. And, one can take from what's happening is that perhaps customs agents in the Netherlands simply see a shipment from India of generics, and then sort of, they think, oh, a red flag goes up, this might be infringing, even if it's not really, because that's what the facts seem to suggest, because 17 of the 18 seizures in 2008 ended up being legitimate, meaning non-infringing drugs. Not just were they not counterfeit drugs, they were legitimate generics, meaning they didn't infringe anyone's patent rights.
If you had no evidence whatsoever, or just a troublemaker, just trying just to shut everybody down, would there be any ramifications against you for doing such a thing? How does that look?
From what I can gather, no. And what seems remarkable about this procedure, at least to me, is how much control the owner of the patent seems to have, as opposed to the alleged infringer, which would be the Indian manufacturer. But you might know more on that than I do, of course.
I don't know what the ramifications for that would be. Yeah.
Any questions? Well, I'm again so impressed with the ambition of the project and how well this the argument was put forth in such a stellar manner, and really doing the series proud. And thank you, Melissa, for presenting us such a fine piece of scholarship today, Professor LaBelle for participating and giving us her thoughts and response. Thank you all for coming. And Melissa, as we always do, we provide you with a pen with your name on it as for participating and being one of our 2010-2011 student scholars. Thank you all for coming, and hope you'll come back April the
17th, I believe it is. It is April the 14th, April the 14th at 4:30 for the last presentation by third-year student Jay All, who will talk on pursuit of the general public performance right in the area of sound recording. So, thank you again. Please join us in the atrium for our reception.
Really had a good rapport.
Great job. Thank you.
Is there